So a case challenging the NFA and its restrictions on SBRs is now in front of the Supreme Court. This case asks for the Supreme Court to find that the NFA and its SBR restrictions are in fact a violation of the Second Amendment. This is a huge case which has huge implications, so let's break down what is happening. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is First Form. First Form's an amazing company. I got to spend some time with them, just this last weekend out at their Summer Smash event. I can't, recommend them enough. Their culture, what they believe in is, unparalleled. They believe in freedom. They believe in the Second Amendment, and they support what we do here on the channel. So if you're trying to get healthier, if you're trying to get some supplements, I highly recommend them. Again, pro-freedom company. They have a ton of apparel that I also recommend as well if you're just looking for, some casual wear or also workout gear. I can't recommend them enough, and if you use my link down below and order something $50 or more, you can get a free 4-pack of energy drinks. As I mentioned in the intro, in this video, we're going to be talking about a very important case that is now in front of the Supreme Court seeking review of this critical NFA and SBR issue. This case is a challenge to the NFA as it applies to SBRs and those various restrictions. This challenge asks for the Supreme Court to find that those restrictions are unconstitutional and that they do violate the Second Amendment. And also very importantly, it asks for the Supreme Court to find that SBRs are protected arms. This petition also focuses on how the Supreme Court needs to finally step in and correct a lot of lower court confusion and defiance, and finally clarify which arms are protected by the Second Amendment. Now, coming off the heels of the Supreme Court recently denying review to the rifle and magazine ban challenges, this case kind of maybe has a long shot, has a kind of an uphill battle, but the NRA is trying to get the Supreme Court to finally address this critical issue. Now, this case we're talking about is Rush versus the United States, and this case here involves Mr. Jamin Rush, who was charged with possessing an unregistered SBR in violation of the NFA. As you're all aware, the NFA requires registration and taxation of certain firearms, including short-barreled rifles, and violations are punishable of up to 10 years imprisonment and $250,000 in a fine. Now, in this case, Mr. Rush moved to dismiss the indictment, arguing that the NFA's registration requirement violates the Second Amendment. The court here on review denied that motion, concluding that the short-barreled rifles in question are dangerous and unusual firearms, and therefore they are not protected under the Second Amendment. They found that they are not arms. Mr. Rush entered a conditional guilty plea, but he preserved his right to appeal to the Seventh Circuit, which he then did do. He appealed up to the Seventh Circuit Court of Appeals. Now, on review, the Seventh Circuit Court of Appeals affirmed the district court's decision, to not dismiss the case, and they relied on the Supreme Court's precedent in U.S. versus Miller. And in that case, the Supreme Court upheld restrictions on short-barreled shotguns specifically, but there was a lot in that decision that here the plaintiffs are arguing do not apply to SBRs. The Seventh Circuit found that Miller remains controlling precedent and that the NFA's restrictions are consistent with the historical tradition of firearms regulations as defined in Bruin. Mr. Rush has now filed his petition to the Supreme Court asking for the Supreme Court to reverse what the Seventh Circuit said and also to find that the NFA and its SBR restrictions do in fact violate the Second Amendment. Now, the question presented to the Supreme Court to address in this petition is whether the Second Amendment secures the right to possess unregistered short-barreled rifles that are in common use for lawful purposes. In the petition, the NRA argues that since the Supreme Court issued Bruin, courts across the country have struggled to answer the many questions resulting from the court's new analytical framework. In particular, the debate as to what constitutes a bearable arm covered by the Second Amendment has revitalized in relevance. This case presents several issues that are dividing lower courts and is a suitable vehicle for this court to clarify what arms the Second Amendment protects. So one of the interesting things about this petition is that the case, although it deals directly with SBRs and the NFA and how maybe the NFA arbitrarily restricts those of certain types of firearms, this challenge here also is seeking for the Supreme Court to clarify what other types of arms are covered by the Second Amendment. They want the Supreme Court to step in and finally address this issue of what are arms for the purpose of the Second Amendment. This could impact other issues like other state rifle bans and magazine bans and other restrictions that states and maybe lower courts have put on various items by saying that those are not protected arms. The petition argues that the Second Amendment protects all bearable arms, including short-barreled rifles, which are in common use for lawful purposes. It challenges the Seventh Circuit's interpretation of SBRs as non-arms under the Second Amendment. They state that the Seventh Circuit has manufactured its own test, which seemingly cannot be satisfied. In this case, the court paradoxically dismissed short-barreled rifle popularity and proliferation as having little jurisprudential value, while simultaneously concluding that Rush failed to prove that they are commonly used for lawful purposes. Although the court also claims that its test is basically compatible with Bruin. Bruin's author, joined by Heller's author, condemned it for flouting our Second Amendment precedents. So the petition asserts that SBRs are in common use, and they cite statistics showing that there's at least 532,000 registered short-barreled rifles in the United States. Now, that number, maybe is an old number. And then also when you account for the ATF trying to say all braced pistols are also SBRs, that number is way higher. The NRA also criticizes the Seventh Circuit for dismissing evidence of their widespread lawful ownership and use. So here you have the United States government, the ATF, saying, SBRs are not used lawfully for lawful purposes. They're not owned in a high enough number. However, all the statistics and actual ownership show that they are, in fact, very common. But even there, the Seventh Circuit said, well, the number really doesn't even matter. They also argue that the NFA's registration and taxation requirements lack historical support. They argue that the historical regulations cited by the government here, such as colonial era unlike militia laws and taxation statutes, that they are not relevantly similar to the modern NFA and all the basis that was used for the modern NFA. The petition also points out that the U.S. versus Miller case, which is heavily cited to and relied on by the federal government, did not conclusively determine that short-barreled shotguns are unprotected by the Second Amendment, and also Miller dealt specifically with short-barreled shotguns and really did not address SBRs at all. The Miller case also did not address what happens if short-barreled shotguns or short-barreled rifles are owned in the millions for common uses for lawful purposes. What happens when the number balloons up to a number, that they are clearly in common use? What happens then? In this section, the NRA argues that because the Miller court declined to conclude that short-barreled shotguns were protected arms, Miller stands only for the proposition that the NFA's restrictions are valid as applied to arms that are not protected by the Second Amendment. But this says nothing about arms that are protected, such as short-barreled rifles today. Moreover, Miller's holding and focus on whether short-barreled shotguns were protected suggests that the NFA's restrictions would be unconstitutional as they apply to protected arms. So the NRA argues that the Miller case does not stand for what the Seventh Circuit is arguing or what they found, and it only stands for the idea that the NFA is lawful if it's used against only unprotected arms. But what happens if an arm is clearly protected by the Second Amendment? However, since SBRs are in common use for lawful purposes, and in my opinion, they're clearly protected arms, the NFA's restrictions should then be found unconstitutional as they apply to those protected arms. And in the end, they asked for the Supreme Court to grant cert to resolve this issue and provide guidance on the scope of the Second Amendment and how does it protect certain items like short-barreled rifles and other arms. What type of arms are protected by the Second Amendment? This is a question that the Supreme Court has not fully fleshed out. So this is a really interesting and very important case. You have a pure NFA/SBR case dealing with the Second Amendment that is on the merits in front of the Supreme Court, seeking review and ultimately asking for the Supreme Court to strike down what the Seventh Circuit said. Now, whether the Supreme Court will take this case is kind of anyone's guess. They just punted the rifle ban and the magazine ban cases, so the odds are that maybe they're not interested in the NFA and SBR challenge because, that was a leap above just looking at rifle and magazine bans. However, the fact that this comes out of the Seventh Circuit and that decision, and it's led by the NRA, maybe gives some sort of value, to this case. And Kavanaugh also stated in the denial of the rifle ban case, Snope, that maybe next term or maybe in a couple terms, they would address similar types of issues of rifle bans and other types of arms bans. It will also be interesting to see how the Trump administration responds to this petition because, again, this is a challenge being defended by the United States government. They're trying to defend the NFA. What I suspect might happen here is maybe they're going to do something similar to what we just saw them do in the Fifth Circuit Peterson suppressor case. Maybe you would have the Trump administration argue that the NFA and SBR restrictions are constitutional, but also they would then say to the Supreme Court that they agree that the Supreme Court should review and resolve this critical issue. And I will note that typically when the United States government asks for Supreme Court review, the Supreme Court often grants that review. So this is a case we're going to be watching very closely because it has a lot of ramifications, not just for the NFA and SBRs, but other types of arms bans like rifle bans and magazine bans, and could impact some of those state assault weapon bans or so-called assault weapon bans and magazine bans as well. So we're going to be watching this closely, and as I get more information, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.